it's reported in the 2015 volume of Electronic Kenya Law Report, reiterated the importance of respect for orders of the court and the obligation by both parties to the suit and third parties who may be beneficiaries of acts in contempt of orders of the court. In that case, the court held that the orders earlier issued stopping the transfer of a property to a third party still held even after the property had been transferred to third parties who may not have been aware of the court order. In the present case, it is clear that the second and third respondents acted together with the Director of Immigration to defeat the orders of this court that required the second and third respondents to produce the applicant before this court so that he could be dealt with in accordance with the law. It is tried that any action done in contempt of the orders of the court is illegal and has no capacity of being given recognition in the eyes of the law. It is evident that the action taken by the Director of Immigration in furtherance of the contempt of the orders of this court is illegal, null and void, and cannot have any legal effect. As of 3 p.m. on 6 February 2018, the applicant was required to be presented before this court. In fact, at that time, although the applicant was under the custody of the police, he was awarded of this court pursuant to the order issued by Honorable Edwin Mulochi at Kajiado Chief Magistrates Court. This court is of the view that to remedy the contempt of the orders of this court, it shall give orders that shall give the second and third respondents and the Director of Immigration the opportunity to purge the contempt and in the process assert the authority of the court. The only way that the second and third respondents and director can purge the contempt of the orders of the court is by restoring the status quo as it existed at 3 p.m. on 6 February 2018. Mrs. Alice Chege is my daughter's favorite teacher at Alliance Girls High School. When the performance of a student who normally performs well drops, she usually makes the following statement: we must restore the factory settings. This is in allusion to a mobile phone whose software has been corrupted, and for it to function again, its setting must be restored to the factory settings. In Mrs. Alice Chege's situation, it means that the student must strive to improve performance to be as it was before. In the circumstances of this case, the purge of the contempt of the orders of the court, the status quo ante must be restored. These are the orders this court will make to give opportunity to the second and third respondents to purge the contempt of the orders of this court. 1. The declaration dated 6 February 2018 issued by Fred Matiang'i, Cabinet Secretary, Minister of Interior and Coordination of National Government in respect of the applicant on advice of the Director of Immigration under Section 33(1) of the Kenya Citizenship and Immigration Order Act 2011 is hereby declared null and void and of no legal effect because it was issued in contempt of the orders of this court. The declaration dated, that is number 2, the declaration dated 6 February 2018 issued by Fred Matiang'i, Cabinet Secretary, Minister for Interior and Coordination of National Government in respect of the applicant on the advice of the Director of Immigration under Section 43 of the Kenya Citizenship and Immigration Act 2011 is hereby declared null and void and of no legal effect because it was issued in contempt of the orders of this court. 3. The valid Kenya passport of the applicant shall be surrendered to the Deputy Registrar of this court by the Director of Immigration within 7 days of this ruling. That passport shall be dealt with by the court with jurisdiction in accordance with the law. 4. The second and third respondents shall personally give a written undertaking to this court that they shall comply and give effect to the orders of this court. The undertaking shall be presented to this court within 7 days of this ruling. 5. For avoidance of doubt, upon compliance with the orders of this court, the second and third respondents and the Director of Immigration are at liberty to defend the validity of the action before a court of competent jurisdiction. 6. Leave is granted to the second and third respondents and any aggrieved party to appeal against the decision of this court.